In 1776, America declared that its 13 states were sovereign and fought Great Britain in the War of Independence. In 1787, the creators of the United States Constitution debated over how America was to be run, what rights to grant its citizens. In 1861, the country was divided by civil war, which decided the future of slavery. But for more than 6 years at the end of the 19th century, the United States faced arguably its greatest challenge yet. The country was asked, what is a tomato? Well, tomatoes are fruits. Botanically speaking, a fruit is the part of the plant which contains the seeds. Of the concern of the United States was more so the definition of a vegetable. They simply lacked a consistent one. Some regarded them to be edible parts of plants that aren't fruit, others plants that require cooking before consumption. What was clear is that what people thought a vegetable was differed depending on the individual, and this lack of clarity over what a vegetable actually was essentially the subject of Nix v. Hedden, a case which actually made its way to the Supreme Court of the United States. In 1883, President Chester A. Arthur introduced the Tariff Act, a series of protectionist measures which included a 10% tax on imported vegetables, but not fruit. The John Nix and Co. Fruit Commission was one of the only companies which imported produce into the United States, and they were rather disgruntled about having to pay duty on a product that, by the botanical definition, should have been exempt. The company sued Edward L. Hedden, the collector of the Port of New York, on the 4th of February 1887. After more than 6 years since the initial lawsuit, the case was to be decided by the Supreme Court. The primary strategy of John Nix and Co. was to illustrate how there was no special definition of fruits and vegetables in the business, so the botanical definition of tomato should be used to apply to the Tariff Act. They evidenced their case by providing 3 separate dictionary definitions and enlisting 2 witnesses who had worked for decades in the industry to confirm that they did not, nor did anyone else in the business, use definitions contrary to the botanical ones. The defendants also utilised the dictionary as evidence, specifically for the definitions of the word pea, eggplant, cucumber, squash and pepper. Each are botanically fruits, but the very same dictionary as used by John Nix and Co. did not consider them such. This was the crucial element to the court's decision, which sided with the defendants. Botanically speaking, tomatoes are the fruit of a vine, just as are cucumbers, squashes, beans and peas. But in the common language of the people, whether sellers or consumers of provisions, all these are vegetables, which are grown in kitchen gardens and which, whether eaten cooked or raw, are like potatoes, carrots, parsnips, turnips, beets, cauliflower, cabbage, celery and lettuce, usually served at dinner, in, with or after the soup, fish or meats which constitute the principal part of the repast, and not like fruits generally, as dessert. The court sided with Hedden because there was no evidence that the Tariff Act of 1883 was using the botanical definition of tomato. So instead, the common definition should be used to determine what the Tariff Act meant by vegetables. And that includes the tomato. So, despite tomatoes being fruits, in the United States they are by law vegetables. Ask someone from Tennessee and they might tell you they are fruits, considering their state fruit is the tomato. Activists in New Jersey attempted to make the tomato its state vegetable in 2005, and Arkansas smartly sits on the fence in this ongoing debate by having the tomato as both its state fruit and state vegetable. Clearly, the debate of whether tomatoes are fruits or vegetables is one that rages on today.